You were in a terrible car accident suffering horrendous injuries, and you know that they did something wrong, that they were careless. But now you have no choice but to bring a lawsuit. The defense refuses to offer you a dime, except when you get to trial 2 years later. Now they make you a significant offer. What do you do next? You want to learn the answer? Come join me as I share with you this great information. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury trial lawyer practicing law here in the state of New York. This happens in every single case. The defense always refuses to acknowledge responsibility. They always refuse to acknowledge they did anything wrong. And so now what happens? Now you get frustrated because you learn that the defense, the person who caused your horrible injury, is claiming, hey, we did nothing wrong. Don't blame us. Ultimately, over the course of time, they turn around and say, you know what? Well, maybe if we did something wrong, you're also at fault. And then they'll turn around and say, hey, listen, if we're partially at fault and you're partially at fault, well, your injuries couldn't be as bad as you claim they are. That's exactly what happens in every one of these civil lawsuits, where we are trying to obtain compensation for all the harms and losses and injuries that you suffered. So what happens now? So now we have no choice but to go all the way through the litigation process. And most of these cases do not resolve until we get to trial, or sometimes even during the course of trial. So now let's say, for example, in your car accident case, the defense turns around and says, hey, we have no responsibility here whatsoever. So you go ahead, take your chances at trial. But now, as they get to trial, they realize they've got significant problems. They realize that the person who was driving their car clearly was at fault and was careless. And now they start to offer money. In this instance, if they offer you a significant amount of money, what do? You turn around and say, hey, you forced me to go to trial, you forced me to bring this lawsuit through 2 years of litigation, and now you want me to settle this case? There are some injured victims who will turn around at that point and say, you know what? I want to take this case to a jury. I want a jury to put a price tag on what my injuries are worth. Let the defense recognize that they made a huge mistake in not trying to settle this case at the very beginning or during the course of this litigation. Is that a smart move? The answer is maybe and maybe not. There are a lot of factors that go into answering whether or not that question is a smart move. You know why? Because there are always inherent risks when you go to a jury. So why do I share this great information with you? I share it with you to give you an insight and an understanding into what goes on in the litigation process, in a car accident case, in a medical malpractice case, and in a wrongful death case. You know, I realize you're watching this because you likely have questions or concerns about your own particular matter. Well, if you do have legal questions, what I encourage you to do is pick up the phone and call me. You know, this is something I do every single day, and I'd love to talk to you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at Oginski-law.com. That's it for today's quick video. I'm Gerry Oginski. Have a fantastic day.